This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Thank you for joining me, Dr. Steinberg, with Discussions at the Roundtable, our podcast about expert witnesses and all things expert witness related. If you can give me a little bit of background to your area of expertise, I believe you have two, correct?
I do. I am a physician. I'm an internist by training with a board certification in addiction medicine. And therefore, on the medical side, I get asked to be a forensic expert in a lot of cases that have drug or alcohol issues. They could be criminal matters such as DUI, custody issues about fitness as being a custodial parent, work-related issues with drugs and alcohol, medical malpractice in terms of wrongful death or proper management and use of controlled substances, alcohol factors in behavioral issues, et cetera. So that's one area of medical expertise. I've done a few in the general medical realm where my expertise is internal medicine, is metabolic disease and non-interventional cardiovascular disease, high blood pressure, heart attacks, cholesterol, diabetes, stuff like that. My other area of expertise is in explosives and pyrotechnics. And the background there is about 30 years ago, I became a professional firework display operator, joined an association called the Pyrotechnics Guild International, became president, participated in the National Fire Protection Association code writing process, was tapped by the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, to be a civilian contractor trainer for ATF special agents who were certified explosive specialists, which I did for 8 years. I also taught a few classes over a 10-year period, 2005 to 15, for the New York City Police Department Bomb Squad. And I continue to do bomb squad trainings. I did one for the Iowa State Police on August 3rd of this year. And I also participate in display operator training. I've written a textbook. I participate in code writing. And in the state of Maryland, I'm the person in the fire marshal's office who writes our licensing examinations, the test that you take if you want to be a professional display operator. So on the one side, it's chemistry and explosives and pyrotechnics and rules and codes and regulations. And on the other side, medical stuff, particularly where addictions, drugs, alcohol issues are involved. They're two separate CVs and two separate careers, both involving my work as a forensic expert. I was actually asked at deposition once by an attorney. He said, well, why don't you put them together? And I said, because they're completely separate. He said, well, you could put them together. I said, no, it doesn't work like that. He goes, why? And I said, because the explosives guys ask, why would a doctor want to do this stuff? And the medical people go, what are you, freaking crazy? So they're just separate. I keep them that way.
What was the first matter that you testified or was retained as an expert witness? Was it the medical or the pyrotechnics?
That's a great story, Michelle. My very first foray into the forensic expertise field. People ask, well, how do you get into that? Basically, you have to prove your bona fides. You have to be expert enough that someone calls you up and asks for an opinion. And my very first forensic expert case in explosives and pyrotechnics, I've done a few in the medical field over the years, but in pyrotechnics, the first case was a call from an insurance attorney in New York. And the case was Nizio versus Faulkner, 1996, I believe. And she said, we have a case where our insured was doing consumer fireworks at a party at his house, and someone who was at the party, a 17-year-old boy, was injured and burned by one of the fireworks and is suing the homeowner. Can you help us in this defense? Well, the role of a forensic expert, as we started in our pre-podcast discussion, is not to determine credibility. That's the finder of fact, the judge or the jury. It's not to litigate the case. That's the attorney. The role of a forensic expert has two dimensions. One is to be technically expert to tell the retaining attorney what happened, and specifically, are there any breaches of statutes, codes, or regulations? What happened and how? Is there a breach of a standard? The second role of the retained forensic expert is in interpretation and offering opinion. In trial, everyone else is limited to testifying to facts. The role of the forensic expert is highly privileged because the forensic expert is allowed to offer an opinion, which is introduced as evidence. The opinion can't be just completely out of thin air. You're required to substantiate it, but only the forensic expert is allowed to testify to opinion, if substantiated, where everyone else testifies to I saw, I heard, I did, facts only. So here we go with the case. I said, well, you send me a retainer check. You don't want to do work until you've been retained. And of course, the first thing you want to do is establish, before you do anything with an attorney, who are the parties? Are there any conflicts? And we can do that in a follow-up call. What does it mean to be conflicted out of a case? We'll talk about that later. No conflict, so send me my retainer agreement and a check to retain me and the case file. And she sent the check, the retainer agreement, the case file. And I called her up and I said, you don't have anything to worry about. She said, how do you know that? I said, because the boy wasn't burned by fireworks. He had burns over his left ear that were full thickness skin burns down to the subdermal fat that required skin grafting. And she goes, is that an opinion? I said, no, in this case, that's a fact. He was not burned by fireworks. She goes, well, how do you know that? I go, well, you have the same pictures I have. I said, pull them out, look at them. I said, you see? She goes, no. I said, his hair is intact over his left ear. There are only two ways you can get a full thickness skin burn and leave the hair intact. One is a hot liquid. Actually, you got scalded. The other is a hot surface, a water heater, a heating blanket. I said, the boy fell asleep on a heating blanket, or I don't know, he knocked a pot of scalding water over on him, fell asleep. In the morning, he woke up, he's burned. His mother looks at him, oh my God, go to the hospital, skin grafts. But the hair is intact. It is impossible for a flaming projectile from a firework to streak by his ear and burn the skin full thickness with a flame while leaving the hair intact. They wanted $325,000. You can go back to them and say, we're not paying you anything. She went back. The case was withdrawn. Plaintiff's attorney didn't want to invest any more time and effort into it. And then the funny part is, she said, well, you didn't really have to do any work. Could you send us our retainer check back? I said, yeah, right. I said, the work that I did was saving you $325,000 or some portion thereof. She said, but it didn't take much work. I said, no, only 20 years of understanding medicine and fireworks. She goes, well, if you send us the check back, we like what you did. We might use you again. I said, oh, really? I said, have you ever had a fireworks case before? She says, no. I said, you know what? They're pretty rare. I'll skip the repeat business. I'm not sending you your money back.
Right. Wow. I was going to say that almost reminds me of just one of those stories where, literally, to your point, unless you were in the position that you're with your expertise, they're just not going to see that. They're not going to know that. So it's,
I liked it because it was classic Sherlock Holmes. The answer staring you right in the face if you know how to interpret it.
Do you find that you have to prepare, or you're set up differently as an expert witness when you're testifying on behalf of the government versus regular? Do you find a difference?
Yeah, I've only testified on behalf of the government in a criminal matter twice. Once was a medical issue in the state of Maryland, where I worked with the state's attorney in the prosecution of a physician. It was a drugs for sex case. I've got a bizarre sense of humor, I admit it. But the state's attorney, Stephen Lemme, Lemme, called me up and he said, Dr. Steinberg, would you be willing to testify on behalf of the prosecution against a physician? Well, I've been raised by lawyers, so I said, well, what is the physician alleged to have done? And Mr. Lemme says, with indignation, he was trading drugs for sex. So I paused a little bit and I said, you mean You can't do that? And oh my, there was this long silence on the other end of the phone. I could just see him like, my God, what do they all do this? And then I'm just kidding with you. I said, yeah, I'd be willing to look at the file. And oh boy, was that a lesson? Like, in your initial things about podcasts, what did you learn that you didn't know then that you know now? Here's what I learned in the case of Maryland versus Lebson, Lebson. Steve Lemmy, the assistant state's attorney, said, look, in the prosecution, we're going to have you testify whether these prescriptions were medically indicated or not for controlled substances. And we only need a few hours. So it's a Monday, we're in court, and I go through the prescriptions, and there's no medical indication, no documentation, no disease being treated, no diagnosis. And I'm done. I did what you asked me to do. Then I learned about cross-examination. So after Monday morning, I guess my testimony, Dr. Lebson's attorney says, well, Dr. Steinberg, was this prescription? What about this one? There are thousands of these things. 26 respondents complained, and there are thousands of prescriptions. And he's tying me up on the stand Monday afternoon. I only thought I'd be there a day. So we go back into court on Tuesday. And privately, I'm talking to Mr. Lemmy, like, you didn't tell me about this. Here's the lesson for forensic expert. We're in a lower level trial court. The way it works is you have a constitutional right to confront your accuser. The attorney for the doctor was saying, look, you can end this at any time. I understand we're taking you out of your office. You only plan to be here one day. If you need to go back to your practice, you can go back. The trick is, the technicality is, if I don't complete cross-examination, they had no hope of winning a trial, but what they wanted to do strategically was to win on appeal, because I was the state's expert case. And if they're not allowed to complete the cross-examination, then on appeal, all of my testimony is stricken, and the appellate court doesn't try the case. They only read the record of the trial court. And if there is no expert testimony that these were not medically justified prescriptions, they would win on appeal.
Wow.
You learn these things as you go along.
Tricky.
So I cheerfully complied with Tuesday and Wednesday. Privately, I was not happy, but on the stand, always maintain a cheerful demeanor. I mean, not joking around. You got to be serious, but be pleasant, be civil, be cordial. Do not let anyone get under your skin. The minute you're angry, you've lost. Okay? So just relax. And what I did was I slowed down the attorney. So he'd ask, what about this prescription? I said, well, let me see the record. No, just give me your general opinion. I'd say, sir, a man's career and reputation are at stake. I want you to have full opportunity to conduct this defense. Let's look at the actual record. And I was slowing him down. Monday afternoon, all day Tuesday, all day Wednesday. We go into Thursday. Now, meanwhile, of course, Dr. Lebson is paying this guy hundreds of dollars an hour, and there's no end in sight. It was in March. And he said, Dr. Steinberg, I know we're in our third day of cross-examination on Thursday, third full day. If you have to return your practice, you can. We'd be happy to excuse you. And I said, sir, this is a serious process. I don't care if we're here into April when the crocuses are blooming. I want Dr. Lebson to have the opportunity for a thorough defense, and I am happy to postpone and obtain coverage for my practice as long as you need. We can go into April if you want. We broke for lunch, came back the afternoon. They rested their case.
They're done.
My cross is complete. Well, they didn't rest their case. What they did was they said, no further questions. You're dismissed. Cross-examination is complete. It's in the books. Dr. Lebson lost to trial court. There was no successful appeal. We're done. The government in criminal cases typically wants to use sworn agents, ATF agents, FBI agents, sheriff's deputies, police officers, the criminal lab techs, etc. They very rarely use civilians. Sometimes in civil litigation, they'll reach out. Department of Labor, OSHA, Occupational Safety and Health Administration's reached out to me, but they have in the fireworks world particular experts they like working with. But there was a criminal case, a manslaughter case involving a fatality at a fireworks show where a crew member was killed. And I worked for San Bernardino County. The prosecutor, the district attorney, was a lady named Amy Zeta, Zeta, and they didn't have a pyrotechnics explosives expert competent to testify in this area. So they reached out to me, and I reviewed the case and agreed to testify for them. And in California, they do. Every jurisdiction is different. You'll learn this. In Pennsylvania, they don't depose experts. You stand on your report. California has basically what they call a preliminary hearing. It's exactly like a trial without the jury, but you're in front of a judge. There's direct examination, cross-examination. You give testimony, and these two licensed operators had been grossly negligent. And you learn criminal standards. The standard for manslaughter is the action was so negligent that a reasonable person could have foreseen that a death would result. And the two wanted to plead to reckless endangerment, a lesser criminal charge, or something else. The state wanted the idea that you killed somebody, manslaughter, to be in the case. And I testified at the preliminary hearing, and they pled guilty to manslaughter. And that was the end of that case. And then I went back and changed in NFPA 1123 a piece of code to make it absolutely clear, even to the most limited person, why what you did was wrong. It was the case of the state of California versus Mulligan and Loux. And the kid who was killed was Willie Calabrese, and his mom was Janice Calabrese. And I changed the code. It took me 3 years to do it. I called it Willie's Law. I actually wrote the code, and I provided a copy of that 1123 edition for Janice Calabrese and for Amy Zeta, so that this isn't going to happen again. So those are my limited experiences being a government witness in a criminal trial. Usually in criminal matters, you're going to be retained by the defense. The government's going to use its own employees. As I discussed with civil, they often have a fixed small pool of experts they like to go to. So I've testified state and federal, criminal, civil, etc. Two of the other things we mentioned, one is who do you testify for? You don't really want to get pigeonholed. I mean, it can happen to you. For instance, sometimes in the fireworks world, insurance companies will say, well, if you did a case against us, if you were ever a plaintiff's case, we don't want to use you for defense. I had an inquiry for a case in Georgia. I'm perfectly competent, happy to take the defense case. And the client said, our carrier won't let us use you because they say you're conflicted by virtue of having done a plaintiff's case against a client insured by this carrier. Well, that's a problem. And basically, then they're going to pigeonhole you. My work in civil matters in the med mal side is 70% defense, 30% plaintiffs. And in the fireworks and explosives, it's about 60% defense, 40% plaintiffs. You don't really want to get pigeonholed exclusively one side or the other. It may happen to you, but you don't really want to say, I only like doing defense work, I only like doing plaintiffs. One of my three sons asked me, he says, well, what are your favorite cases? Because this relates to who retains you. I said, my favorite cases where I actually have something useful to do, which means the defense calls me and I say, okay, from my read, the plaintiff's theory is not substantiated, but you're going to need an expert to help you defend. Or a plaintiff's case where, yes, an injury was done here, I see the breach of code, but you're going to need an expert to help you. My least favorite cases are where we wrap it up and we're done, where the defense retains me and I say, look, here's the breach of standard. The sooner and less expensively you resolve this, the better. If you want to argue, you can argue, but I'm going to tell you what happened. Yes, the plaintiff's theory of causation alleging a breach, not just a breach of code, but a breach that was proximally and causally related to the injury is able to be established with certainty. Thank you, we're done. Or a plaintiff, funny story, I had a plaintiff lawyer call me, he wanted to retain me, and I said, no, it wasn't defective fireworks. It was operator error. This fella breached safe operating procedure. He did it to himself. There's nothing defective. He thought the fire prematurely ignited or something. And a few months later, this attorney had reached out to another expert who doesn't like to do forensic work. A lot of people who are expert don't want to get involved in forensics, who sent the attorney back to me and said, you ought to call Dr. Steinberg. He really knows how to do this forensic stuff. And so what I did was I said back to the referring expert, copying the attorney, I said, oh, Mr. So-and-so has already discussed the case with me. And, he would like to find an expert with a different perspective. In the pyro explosives world, there's a very small pool of people who are truly competent and willing to do forensic work. There are a lot of people who can be expert, but a lot of people, they find it's not to their taste. It's,
Yeah.
it's an adversarial system. It can get a little testy. A lot of people don't, they like to just say, well, this is what happened, but they don't want to undergo 3 hours of withering cross-examination. I just sat through a 3.5-hour deposition by opposing counsel last Wednesday. And, we're civil and we're cordial. But no, you're going to be held to justify what it is you're testifying. You're not going to get a free pass.
Right.
The other side's going to come at you hammer and tong. They're going to try and impeach your credibility. When you're contacted as a forensic expert, first thing you do, go, who are the parties? If you have a prior relationship in one of two areas with any of the parties, you're called conflicted out. You have a conflict. One is if you have an ongoing business relationship. Like if a firework company is being sued and they want me to defend them and I'm an ongoing consultant for their training or procedures, I have a relationship with them that could be construed as biasing my opinion. The other is if anything confidential has been divulged to you, which is why I won't look at anything or let you talk about the case until you've retained me. Because a plaintiff's lawyer could call me and say, look at this file and tell me what you think. And you look at it, and then the defense calls you and you say, I'd rather help you. I think you've got the better case. But now I have a conflict because I've seen privileged communication. I've discussed the details of the case. I've formed an opinion. You don't want to be conflicted. So first thing you establish before you tell me anything other than your name, who are the parties in litigation? Okay, if I don't see any conflicts there, what's the nature of the allegation? If there are no conflicts and I'm competent, if you want to retain me, you can ask general questions. Well, what kind of cases have you done? What's your expertise? But you don't look at any case materials or give any opinions until you've established that you've been retained.
If you are given very limited time to prepare for a case, do you have a system in place?
I've had a fairly quiet year, which has been nice and relaxing. I generally am retained in 5 to 20 cases per year. I have anywhere from 10 to 25 active cases at any one time. But active just means they haven't been resolved. When things get really busy, I take a 5x8 card, I write the case caption, the name of each case, and the most immediate deadline, expert report due by, deposition date by. And so it's like being an air traffic controller where I have all these cases and I make sure I keep them queued in the proper order and land them all. With respect to urgent deadlines, as I told you at the beginning, I just got retained in a case where they have to disclose experts by Monday, October 3rd, and today is Monday, September 26th. So you'll learn all these terms. What does disclosure mean? That means all they have to do is say, this is my expert. So the other side can, check you out or research you or whatever. You don't have to read any materials. You don't have to, have an opinion yet. But you'll find there are deadlines for disclosure of expert, which means you're retained, for preparation of a report, which means you have to review the case file, for completing testimony at deposition. Every case has what's called a scheduling order that's issued by the judge in negotiation with the litigants, the two parties. It's important that you ask at the beginning of the process when you're retained, are there any deadlines I need to know of? Are there any scheduling order constraints that will affect me? You can ask about the size of the case. My land speed record is I got a call on a win in a fireworks case, retained by check, agreement, and case file on Friday, and reviewed and report written by Sunday, and completed and disclosed on Monday. I don't like working like that, but I can. In my retainer agreement, I have a clause that says, If you require me to work over a weekend, over a holiday, or produce work product in less than 21 days, a 50% premium to the established rate will apply. And as I tell my kids, what's your comfort factor? It's kind of like, my wife, Joyce, who passed away in 2017, once asked me, I was reading depositions. She says, "Is that interesting?" I said, "Sweetheart, for $6 a minute, I'll read the phone book."
Right? That's true.
So what you do is you establish your rates. What are you worth? What's the market? And then the other is, okay, you want it when? Well, there's a pain factor there. But if you give me a 50% increase in the rate, the pain is worth it. And these are the kind of things you learn by doing it. The first time I didn't have that protection in there, but I added it for subsequent retainer agreements.
Yeah.
There are also some clauses in my retainer agreements, which I tell the people are defensive. I don't have to exercise them. I just told the attorney who retained me today, look, I don't refund unused funds. That's a quirk for me. It's not necessarily standard, but I'll work with you so you don't leave a lot on the table. I work from a 10-hour retainer. I work against the retainer, then you replenish it. But if you tell me you're getting ready to wrap up the case, all right, if you've retained me and I've been through one retainer, maybe replenishment, 10 hours at a time, 20 hours, and you say, I think we're about done. All right, I could agree if you've established some credibility with me to then hold off on replenishing the retainer and just bill you for the hours actually worked. There are times with insurance carriers doing defense work where they won't do a retainer. They'll only let you invoice for hours worked. And then it's your call. It's a forensic expert. Do you want the work or not?
Yeah.
And I've learned over the years, mostly I get my way 85% of the time. But if you really want to do this, you've got to be a little bit relaxed about, if the attorney doesn't have control when you're dealing with an insurer, and I like doing defense work, then you're going to have to live with the carrier's requirements.
Yes, that is true. Well, let's end this with one last maybe kind of story or comment about over your course of your career as an expert witness. Are there any big learning moments that stand out for you where it was an aha moment or the most enjoyable case perhaps maybe you worked on?
Well, not so much, but I'll give you a technique I advise forensic experts to adopt, and then a funny story of testimony at trial that isn't any really a learning experience, but it was. You live for those moments. Like, I can't believe you asked me that. I've been waiting for this all my life. All right. So the first is lawyers will often ask you a multi-part question. They'll say, well, and they like to say, you would agree with me. Whenever a lawyer says you would agree with me, restate it. Don't let them put words in your mouth, particularly at deposition where you're creating testimonial record for introduction at trial. When a lawyer asks you a multi-part question, it will often be as follows. Well, Dr. Steinberg, you would agree with me, A, and you would agree with me, B, so C. And if you say yes, you've locked in A and B. So whenever a lawyer gives me a multi-part question, I say, well, sir, you've actually asked me 3 questions. With respect to A, I don't really agree. With respect to B, I don't really agree. Here's why. But yes, on C, on that final thing, which they ask you is bait because they know you'll agree with it. Yeah, there I agree with you. So when they go, well, you would agree with A, I say, no, well, you'd agree with me with B. No, I really don't. You'd agree with me with C, and C is obviously something you agree with. If you say yes to C, you've locked in A and B. So whenever you're asked a multi-part question, break it down into the components. Whenever a lawyer says, well, you would agree with me that, unless it's totally obvious and you're comfortable saying yes, don't let them put the words in your mouth that are created as your record when you say I agree, restate it. Say, well, I would phrase it as follows, and then testify to what you want to testify to. So here's your funny story. I'm testifying in a workman's comp case in a rural area of Maryland, what we call our Lower Eastern Shore, and I'm the big city assistant professor from the medical school. And basically, the guy was suing his employer. He was drinking beer and smoking marijuana, and he drove the company truck off the road and got injured. He wanted a workman's comp claim. blood alcohol level is 0.22. He's positive for marijuana. There are beers rolling around in the truck. He can't show the work order. He was going to a resort town called Ocean City, Maryland. And I've just absolutely demolished this poor attorney's case. So he decides he wants to impeach. Impeachment means to cast doubt upon your testimony or credibility. When they say, well, what are you charged? Have you ever been sued? No matter how embarrassing the question is, you go over this with your retaining counsel prior, but you just answer truthfully. So he says, well, how much do you charge for you're being paid for your testimony? And you answer, well, I'm being compensated for my time. Don't add the gratuitous, as are you. Just say, yes, I'm being compensated for my time. Well, how much do you bill? At the time, it was $300 an hour. I said, $300 an hour. He's like, oh, these guys, your jury, 6-member civil jury, they're working for $18, $5, $8 an hour, whatever. Just say, look, they don't care. You're a professor from the medical school up in Baltimore, Maryland, $300 an hour. And then he says, and you charge that rate from the minute you left your office to the minute you return. Well, I'm thinking to myself, well, who invented what we call portal-to-portal billing? Lawyers. So I simply said, yes, sir. And then he says, well, how much longer do you think that'll be? And I said, right up until you stop asking me questions. And bam, one of the jurors cracked up laughing. The lesson there is, whenever they're laughing at your opponent, you've won. So I can't believe he asked that.
Right.
But he did. And even the judge had to stifle a chuckle. So, you have these moments, but answer truthfully. They mean that when they say the whole truth and nothing but the truth. Don't fudge, don't shade. You're not trying the case. If you're asked a question, answer it completely, but don't go astray. Don't keep yakking and talking and answer more. You're going to learn, if you're a forensic expert, to carefully understand the question and answer it truthfully, fully, and completely, but no more. It's the lawyer's job to ask you the questions. You're also not allowed to give expositions. You can't just get up and preach. You can only respond to a question. If there's something you want to get in the record that hasn't been asked, the attorney who retained you on what's called redirect or recross will ask that question. So in any case, Michelle, it's been a lot of fun doing this podcast with you.
Thank you.
All my future fellow forensic experts out there. If you like this work, I think you'll really enjoy it. As long as you don't mind, working a little bit far afield the law and learning the rules of the game you're playing in, it's a really excellent component to pretty much any profession. It's a feather in your cap to be able to be ranked as an expert, where people appreciate your ability to provide technical expertise that helps two parties in an adversarial situation come to a fair and equitable conclusion.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.